Yes, Mr. Crosby.
My Lords, for the second time in 2 days, I resume after lunch with a response to a question posed by Lord Justice Singh before the interval. That was the question to Mr. Wolfe, taking the Secretary of State's assumption that there was something inchoate about the situation. It was all rather unclear. What would a reasonable decision maker have done? And our answer to that is, if on the one hand you're contemplating a national infrastructure project that's likely to last 6 decades, on the other you have the Paris Agreement that represents the political consensus on the boundary between humanity and catastrophe. And you also have, on the near horizon, your own department's aviation strategy for the UK, and a report from the Committee on Climate Change on Aviation. We say a rational decision maker in those circumstances would not have simply pressed ahead. They would have pressed pause. And that to do otherwise would mean more haste, less speed. It would be unfair to all parties, including the commercial interests at play in this case.
Yes.
My Lords, Mr. Marucci referred to the 6.5-year process leading up to the designation of the ANPS and the inclusion of Julia King from the Committee on Climate Change in the Airports Commission. My Lords, the Airports Commission final report was published on the 1st of July 2015, prior to the Paris Agreement, which was adopted in December 2015. So it is no criticism of the Airports Commission or Julia King to point out that that does not assist the Secretary of State in terms of the relevance of the Paris Agreement. And indeed, if I may take my Lords to page 66 of our supplementary bundle, tab 2. This is back to the government's response to the consultation process.
Yes.
At the top of the page, 842, you'll see more or less this point being made. Several respondents contended that the UK's current carbon emissions targets under the Climate Change Act were adopted before the ratification of the 2015 Paris Climate Agreement and therefore needed to be updated. That's the general point being made. And below you get the government response. And there's nothing there about why the government believes it's not possible to act on the Paris Agreement at this stage. All we have at 847 is the government has concluded that given the range of policy measures available, expansion at Heathrow Airport is compatible with the UK's climate change obligations. My Lords, we say that's yet another instance of where the ordinary reader would look at the question that had been posed, look at the government response, and assume there was some connection between the two things.
Yeah.
What we say the Secretary of State ought to have done, following the adoption of the Paris Agreement, is do precisely what he did after he had designated the ANPS. And for that, you can go to tab 374 of the bundle, supplementary bundle.
374.
Yes.
Yeah.
And this is where the Secretary of State is, pursuant to the work on the aviation strategy for the UK, he's commissioned an expert report, International Aviation and Paris Agreement Temperature Goals. And what the Secretary of State can't say at this point is, well, this postdates the decision. It's December 2018, because it was his choice to have this document after he had designated the AMPS. There's no reason in the world, we say, he couldn't have chosen to commission precisely the same report in time to factor it in to his decision making on the AMPS. It's an example of what could have been done. And his own expert does not back up Mr. Marici's claims that this is all just too difficult. We can't make any sense of what it would mean. What he says, and we looked at this yesterday, and this is the last paragraph on that page 74, second sentence. Therefore, for 1.5 degree global scenarios, any continued emissions of CO2 from aviation beyond around 2050 will be inconsistent with the Paris Agreement goals. And that may not be a statement directly about what the UK's target should be, but it's certainly a statement about the potential relevance of the Paris Agreement to the ANPS, because there can be no carbon dioxide emissions beyond 2050 from anywhere, yet the effect of the ANPS is to increase emissions and at the very least 37.5 megatons of carbon dioxide by 2050. There is a disconnect between those two things that needed to be addressed.
How does that fit with the Climate Change Committee's advice?
My lords, we will come to that. If I may I take that in due course? What we did have from the Airports Commission in 2015, and this is at page 2 of the supplementary bundle. The Airports Commission must have been aware, of course, at this point, of the work around the Paris Agreement that was to come shortly afterwards. In large red letters in the middle of the page, any change to UK's aviation capacity would have to take place in the context of global climate change and the UK's policy obligations in this area. What you also see on the facing page at 264, the CCC considers the 37.5 megaton aviation target and the pressure it will put on other sectors of the economy, sectors used by ordinary people across the country. That is an ambitious goal at the upper end of what is expected to be deliverable. So make that a more stringent target. On the face of it, there's a problem. My lords, just to reinforce that point, now I take you to Friends of the Earth's supplementary bundle, page 129. And this is Caroline Lowe's statement. Go to paragraph 505. What she says halfway down that paragraph, my team forecast that CO2 emissions with both a Heathrow Northwest runway and best use of existing runway capacity would be 40.8 megatons of carbon dioxide in 2050. In other words, with no additional airport capacity anywhere else in the UK, just best use of existing capacity and best use of a new northwest runway, we would already be exceeding the aviation target consistent with the historic 2-degree goal and the minimum 80% emission target. So we say the Secretary of State must have been aware that there would be a problem with more stringent targets. And
So can you give us the comparative figure or where we can find it, the cross-reference?
the comparative, the aviation target figure, my lord.
Yes.
So yes, it is at 264 of the document we were just looking
Yes.
at, the airport's commission report.
Thank you.
And the first line, the CCC's planning assumption requires CO2 emissions from UK aviation in 2050 should not exceed 37.5.
Should we just go back to that? Page?
My lord, that's page 3 of the supplementary bundle
Yeah.
for the airport's commission report.
Yeah.
And
That's your supplementary bundle, isn't it?
it is,
Yeah.
indeed. And for Caroline Lowe's statement, it's Friends of the Earth supplementary bundle, page 129.
Right, so we want paragraph 264. And Caroline Lowe's evidence?
Is Friends of the Earth supplementary bundle 19, page 129. And then it's paragraph 505.
I'm sorry, Caroline Lowe's evidence, you said, was where?
It's the Friends of the Earth supplementary bundle.
Yeah.
And it's all volume 1, tab 9, page 129.
Yes, that's what we were looking at just now.
Yes.
Yes.
And that's where the 40.8 figure occurs.
Yeah.
So what we say is it's somewhat convenient for the Secretary of State to advise himself that the Paris Agreement was not a relevant consideration. Because if it concluded it was a relevant consideration, and has asked himself whether the ANPS was likely to be consistent with any more stringent target at all, his answer was likely to be no. And he seems to have been applying a rule of advocacy instead of a rule of public law. Don't ask the witness a question if you might not like the answer. Mr. Marici says that we failed to address the how and the when questions around the Paris Agreement. And this goes back to this point that the Paris Agreement sets the overall objective, but it's not clear what that means for any particular national government. We say that argument just ignores all the available evidence, which was that by June 2018, the time of the designation of the ANPS, we knew the how because we'd had the very clear, unequivocal commitments from government ministers, Andrea Leadsom and Amber Rudd, from March 2016. The how was to implement a new net zero target in accordance with the Paris Agreement. And if we go back to bundle, Plan B supplementary bundle,
Yes.
page 57, and we've seen this before, but this is just putting it in context. The bottom of that page 57, we have Claire Perry, Energy Minister, on behalf of the government, saying to Parliament, the when. We were the first country in the world to ask how we will get to a decarbonised economy in 2050. And I would hope that we could enjoy cross-party support for something so vital. So she's saying that is the government policy. We want the CCC to tell us how we're going to get to net zero by 2050, which is what, in due course, they do. CCC advise the government how to implement its policy. That then turns into legislation, the will of Parliament. That's the sequence we have. And my lords, it's not coincidence that both Claire Perry and the Secretary of State's own advisor referred to net zero by 2050, albeit the independent experts talking about it globally, Claire Perry's talking about it nationally. This is reflecting an international consensus about what the Paris Agreement means. And if I may turn you to page 48. My apologies, my lord. Page 43 of Plan B supplementary bundle. This is a text of the European Parliament. It goes to page 46. This is again January 2018, around the time of the IPCC report, around the time that's made available to governments. And towards the bottom of page 46, you'll see Amendment 9, 6b. In line with the aim of the Paris Agreement to achieve a balance between anthropogenic emissions by sources and removals of greenhouse gas emissions by sinks in the second half of the 21st century, the Union should aim on an equitable basis to reach net zero emissions domestically by 2050. Followed by a period of negative emissions. So the European Parliament were capable of doing what Mr. Morici says was impossible at that stage, working out the implications of the Paris Agreement, as was his own expert, Mr. Lee. And finally, my lords, on this theme, if we turn to the document presented to you by Mr. Plemming this morning, a note from the claimants in the Borough's case on climate change, and forgive me, I'm not sure where that's been placed in the bundle. Oh, it hasn't been. Okay.
No, not yet.
Paragraph 3 of that document. See, the Mayor himself has a duty to address climate change for Greater London, and published the London Environment Strategy. The London Environment Strategy was published in May 2018. In accordance with the Paris Agreement, the London Environment Strategy set out an ambition for London to be a zero carbon city by 2050. So, my lords, we say the position by June 2018 was that everybody, apart from Mr. Grayling, seemed to be able to understand the implications of the Paris Agreement for domestic, European, city-wide emissions reductions, and they all seem to converge on this figure of net zero by 2050. So why was the Secretary of State not able to take that information into account? Now the answer he gives us, my lords, is that he had available to him the latest assessment from the Climate Change Committee. And that latest assessment said, actually, the Paris Agreement could be consistent with the existing target. And if we could just have a look at the document that he relies on, it's page 113 of Foe's Friends of the Earth supplementary bundle.
Friends of the Earth. Or Plan B, sorry.
It's Friends of the Earth. Apologies.
Yes. page 113 in Friends of the Earth supplementary bundle. Paragraph 458.
Page 29, I think.
Page 29.
I do apologise.
That's right.
Yeah, page 29. Now this, my lords, appears to be the only document relating to the Paris Agreement that the Secretary of State considered in the course of this exercise.
I'm sorry. Page 29.
Starts
Page
page-
29 of Friends of the Earth's supplementary bundle.
Should be tab 2, isn't it? That's the 2016 one.
Friends of the Earth supplementary bundle, tab
Tab 3.
3, page 29, yes.
Yes.
Response to the claimant's reply.
My lord,
Yes.
that is it.
From your
So this is the document to which the Secretary of State attaches such importance, and this is the document which he says reflects the latest assessment from the Climate Change Committee. It is a legal submission.
We're not sure we're looking at the right document, I'm afraid. We've got response to the claimant's reply to the summary ground.
That's the correct document, my lord.
Well, have we already been taken to this document?
Only partially by my learned friend, Mr.
No, I didn't take you to this document. I
No.
took you to what the judgment said about this document. This is the Climate Change Committee's response in these other.
Yeah.
All right.
Yes.
So you've seen what was in the judgment. You haven't seen.
We've seen it. We've seen the extract from it in the judgment.
Correct.
That is why my copy of it has no tabs on it and no highlights.
My lords, this is an unsigned legal submission in a previous judicial review. We assume it's the work of Richard Gordon QC because he was the counsel instructed by the committee in those judicial review proceedings. The context, my lords, if you look at paragraph 1, there was a listing in this court for a permission hearing on the 20th of March 2018. One of the issues was whether the Secretary of State for Bays had correctly interpreted the committee's advice, and the committee did not attend that hearing and made no written submissions. And Mrs. Justice Nicola Davis, as she was then, said she couldn't proceed in the absence of the committee. She adjourned the permission hearing and ordered the committee to produce written submissions within a short space of time.
Yes.
And if we go to page 32, top of that page, what you'll see is the sentence that the Climate Change Committee recommended no change to the existing UK target at that time, October 2016. Not because a more ambitious target was infeasible, but rather because the existing UK target was potentially consistent with the more ambitious global temperature goal, including that in the Paris Agreement. In other words, this isn't the CCC's assessment of 10th of April 2018. This is a lawyer's interpretation of what the Climate Change Committee said in October 2016. So the presentation of this document as an up-to-date assessment by the committee, we say, is completely misleading. And if we turn to the judgment, paragraph 610 of the court below,
Yes.
the description there, the most recently formally expressed view of the CCC is the current target is potentially compatible. But again, that's just not correct. So the real issue, my lords, is not what's said in, we assume, Mr. Gordon's legal pleading. It's what's actually said by the Climate Change Committee in October 2016. And for that, my lords, if we go back in Foe's supplementary bundle to page 19, we see the CCC's actual document, a carefully prepared document of 60 pages. We've only got the excerpt here. Nowhere does that document say the 80% target is potentially consistent with the Paris Agreement. And if Mr. Morici can find somewhere that it does, maybe he could provide the court with the reference. Maybe he would have previously provided the court with the reference. If we turn to page 23,
Just a second, if you would. Yes, page 23.
look at what the report actually says. Emissions pathways indicate that CO2 emissions will need to reach net zero by the 2050s to 70s, along with deep reductions of all other gases, in order to stay below 2 degrees C. That's below 2 degrees C, it's not well below 2 degrees C, which is the Paris terminology. And it then goes on to stay close to 1.5 degrees, which is part of Paris. Emissions would need to reach net zero by the 2040s. And if you look at the box below, it's set out more clearly still. Timescales for reaching global net zero emissions consistent with the Paris Agreement. And this is global net zero emissions. Return to 1.5 degrees carbon dioxide 2040s. Below 2 degrees, and again, I make the point, my lords, that isn't in fact the Paris goal, which is well below 2 degrees. 2050s to 2070s. And if my lords look at the notes below that box, there's a greater level of technical detail, specificity. It says below 2 degree pathways have at least a 66% likelihood of avoiding 2 degrees, which is the old target. In other words, you've still got a 1 in 3 chance of going beyond 2 degrees with net zero carbon dioxide by the 2050s to 2070s. So going back to Mr. Gordon's document, what he seems to mean, and can only mean by saying could be consistent, is imagine, playing Russian roulette with 4 bullets in the gun. Well, you could get lucky. You could be okay. Potentially consistent. And that, we say, is why that statement in Mr. Gordon's legal submission is a very far distance from government policy. That would not be a good basis on which to make government policy. Give yourself, an outside chance of surviving. That's why government policy, as expressed by Claire Perry, was net zero emissions by 2050, which, if you look at the table from the CCC, is right at the sort of limits of what you could justify. My lords, if you recall the weight and the emphasis that Mr. Merici has put on that document, the only document referred to by the Secretary of State in witness evidence, the legal pleading, we just ask the question, which is this, in the context of a decades-long national infrastructure plan and a legal obligation under Section 5.8 to consider government policy, why did he confine his analysis to a legal pleading and not look at all the proper, detailed technical assessments that everybody else was looking at? My lords, once it's clear that in fact the legal pleading is referring back to 2016, it's also clear that it's not at all the latest assessment from the CCC.
Just to be absolutely clear that I've understood your submission correctly, can we please go to page 113 in the FOE bundle? So I can be sure that I'm understanding your point. Do you have page 113?
I do.
That is the witness.
Yes, this is Caroline Lowe's statement, paragraph 458.
This is your point. This is the only witness evidence.
Yes.
And the only the only document referred to in the witness evidence you submit is in footnote 111 in the document referred to, which is the document, the legal submission you've just been showing us.
My lords, yes.
And it's quite interesting to see how Caroline Lowe then concludes paragraph 458. Subsequently, in establishing its carbon obligations, etc., my team has followed this advice and considered existing domestic legal obligations as the correct basis for assessing the carbon impact of the project, and that it is not appropriate at this stage for the government to consider any other possible targets that could arise through the Paris Agreement. Mr. Merici placed a great deal of emphasis on that sentence. What do you say about it?
We say this is just an opportunistic attempt to jump on a line in a legal pleading. And it cannot be a serious attempt to understand the implications of the Paris Agreement. If you confine your analysis to the pleading that Richard Gordon was ordered to produce within a matter of weeks by Judge Mrs. Justice Nicola Davis, it just doesn't seem serious.
Now, Mr. Crosland, how are you getting on?
My lords, just one other point about that document. This is the legal pleading, and it was 15
have you thought about points made by Mr. Wolfe that you would be able to adopt?
My lords, indeed, adopt pretty much all his submissions. These are only additional, so
I
I
see.
certainly won't be duplicating anything Mr. Wolfe has said.
Right. Very well.
My lords, page 35 of the pleading.
Where are we now?
This is Foe's supplementary bundle.
Yes, page.
Page 35.
Yes.
My lords, just above paragraph 28, you'll see the sentence, on this basis, as assessed in 2016, the evidence suggested an at least 80% emissions reduction target for the UK in 2050 could be consistent with achieving a less than 2 degree C goal. I'll always just make the same point again, that isn't the Paris Agreement. The Paris Agreement is well below 2 degrees and aiming for 1.5. So to say, as this document does, that it could be consistent, which only means it might be consistent, it might not be consistent, which isn't massively reassuring. That isn't even linked to the Paris goal. It's linked to some other goal of below 2 degrees. So again, we say this is not serious to attempt to rely on this as the sole basis for your consideration of the Paris Agreement in 2018. And it also follows, since this document was only produced on the 10th of April 2018, that until April 2018 they looked at no documents at all about the Paris Agreement. My lords, I've taken you to a number of pieces of evidence where other parties have come to the conclusion that the Paris Agreement implies net zero emissions by 2050. Our submission is not that that is the conclusion the Secretary of State should have reached. We don't need to go so far. Our submission is much more modest than that. It's simply that he removed blinkers, if he looked around circumspectly, it would have been reasonably clear that the Paris Agreement implied more stringent targets, and he should have turned his mind to what that was likely to mean for the ANPS, and he should have given reasons under section 5.8 to explain how he thought the ANPS was likely to be consistent or likely to interact with government policy on climate change, including the commitments, the very clear commitments we've seen.
Yes.
My lords, various points it seems to have been suggested that there's no cause for concern if we've now got a new target. This is something that can be picked up by other means, whether a development consent process or Planning Act Section 6. And we say that just misses this critical point of principle that there is in this case. The Secretary of State was required to consider government policy on climate change at the ANPS stage and to give reasons. He didn't do that. What he did was interpret section 5.8 as if instead of saying government policy, it read the Climate Change Act section 1. Parliament might have legislated in that way. They could easily have legislated for Section 5.8 to say he must give reasons about how the AMPS complies with the Climate Change Act Section 1, but that isn't what they said. It's a government policy. And finally, my lords, we can return to Plan B supplementary bundle, page 11.
Yes.
And we've looked at this passage before, my lords, but it's this the top left of the top left-hand paragraph and the second sentence. The actions and investments that will be needed to meet the Paris commitments will ensure the shift to clean growth will be at the forefront of policy and economic decisions made by governments and businesses in the coming decades. We say that is consistent with not only government policy, but the purpose of the Paris Agreement, which was to reflect a sense of urgency, a call to action from all governments to act now, immediately, to prevent further emissions being locked in. And we say if the message that comes out from the Secretary of State and from this court is that actually the Paris Agreement is nothing to do with government policy on climate change, and there was no reason to take it into account. And we know that governments all over the world are going to be interested in this decision, particularly because of the UK's leading role on the Paris Agreement and the status it has in that regard. Then the message that goes out will be, well, other governments, you don't need to worry about the Paris Agreement when you make your infrastructure decisions, not unless and until you legislate domestically. And we say, my lords, that would be an extremely unfortunate message and principle to establish, that it's important, we say, to address this as a matter of principle, not simply kick the can down the road to another stage in proceedings. This is the only stage where Parliament had the opportunity to consider the situation and the relationship to their climate change policy. Unless I can assist you further.
Thank you very much, Mr. Crowe.
My lords, to rise just a moment. I understand some of the climate change advocates would like to leave if that's possible, just to enable them to get their paper back.
Yes. Yes, we don't want a long delay.
No, just a minute or so, I think would be enough.
Not because of the climate, I hope.
Is the courtroom cool enough, actually, for the comfort of everybody here?
Quite warm.
Yes. Well, I wonder whether in the short time we take to allow advocates who are leaving to leave, perhaps we could make the room a little cooler.
Well, can I also just check with the court's acceptable for us to not come back next week? And we will have somebody in court next Friday to hear if anybody has any announcements that we need to respond to. But other than that, I hope you accept that we don't sit through the other material.
Yes, of course.
I think it's a cross.
Make the same request.
Of course you may. But there will be representatives of both
There will certainly be solicitor representatives.
Friends of the Earth
Yeah.
and Plan B
There'll be somebody
present in court.
Yes.
Yes. No, of course, you have our permission not to be here. We'll rise until 3 o'clock.
Court rise.
Sorry? Yeah.
No, sorry, I wasn't trying to get rid of him. David asked me about it.
The pregnant pause.
I'll move down to the two to get all your files. Thank you. You're going to get your train? I hope so.
Early half term.
Farm. Large organic farm. No, I was brought up in the country, so that used to be very lovely. That's much big. You probably go to
Good luck next week. I'll see you on it. Thanks so much. I'll certainly be doing that. Yeah.
Heathrow.
That's where he lives.
So he lives just south of Norwich. They're very close to us.
Every day. It's 2.5 hours each way. Every day.
Jim, can I just get these are not confidential?
These are David's actually. So
All my positive reports. Yes, we have to.
You need one of these as well, Ben? No. They're looking a bit.
We are ready.
Court rise.
If you wish me to, sir.
We've made every effort to improve the airflow. Yes, that's a good word. We've opened windows. We're not going to be fighting noise, I don't think, from outside. So I hope everybody's feeling a little more comfortable after those efforts.
Yes, very good. The bad news, I'm afraid, I'll start with this. I'm probably not going to finish today, given the time. I'm afraid. Perhaps we can take stock at the end of the day.
Well, I think we should take stock. What we're contemplating doing anyway is suggesting 10 o'clock start on Tuesday, if that's not going to cause difficulties. We do appreciate the efforts that have been made by Council to not only to prepare the timetable but to stick to it. I can assure those who are yet to address the court that we're not going to be compressing anybody's submissions unduly. Obviously you will all be trying to stick to the time that's allotted in the timetable, but I don't want any of you to feel anxious about coming later down the order, as it were, and not having enough time. These are important matters and we need to give them proper consideration. Mr. Jeffy.
I'm grateful, my lords. After some introductory remarks summarising where these submissions are going, I propose to deal first of all with the law, and that will include dealing with the concept of what an alternative is under the Habitat Directive and also under the SEA Directive, which was a comparison that was drawn in the Divisional Court's reasoning.
Yes.
I'll also deal with the standard of review, in particular whether we're looking at EU law proportionality or whether we're looking at Wednesbury, and if Wednesbury, then what type of Wednesbury.
Yes.
Secondly, I'll deal with the hub status argument as a basis for excluding Gatwick. That's a point on which the appellants lost below. And then thirdly, I'll deal with the mole gap exclusion of Gatwick on ecological grounds, which is a point which the Divisional Court didn't formally determine, but one gets the sense that they were leaning towards the appellants for the reasons that they gave. They didn't need to determine it because I need to win on both points in order to show there are no alternatives.
Yes.
So it wasn't necessary for the Divisional Court to formally determine that.
Yes.
Finally, I'll deal briefly with whether a reference to the Court of Justice may be appropriate or not, and if so, on what basis.
Right. Thank you very much.
Where these submissions end up, my lords, is that the Divisional Court was, in our submission, quite right when it said that the Habitat Directive provides a scheme of substantive environmental protection. It is not just a scheme of procedural protection like the SEA Directive. The purpose and the effect of the Habitat Directive is that when one of, frankly, a very small number of highly protected sites of international importance are affected, only limited development is permitted. And the effect of the legislation, the Habitat Directive, was to constrain the choices which are open to developers and to government. Indeed, that's the very purpose of the scheme. And one feature of the scheme is that where the integrity of a European site will be harmed by a plan or a project, and when there is an alternative solution that either doesn't cause harm to European sites or causes less harm, it is the alternative solution that must be adopted. And at the risk of stating the obvious, the alternative solution will always and necessarily be less desirable from the decision maker's view of the planning merits. Otherwise it wouldn't be an alternative, it would be the preferred scheme which was being promoted.
Yes.
And I would add this because of course I represent the Mayor, who, like the Secretary of State, is a politician, and they both make important and often extremely controversial planning decisions, and often the Mayor is before this court and other courts, referring to the importance of planning judgment. But when the Habitat Directive has the effect of limiting what is permissible in terms of development, the effect of the directive, and indeed what the court does in upholding the directive, is not interfering with the democratic process, but it is upholding the decision of the legislator about what degree of protection those limited numbers of special areas of conservation should receive. Now, one might think that the rules in the Habitats Directive are good rules, or one might think they are bad rules. But nonetheless, they are the scheme which the legislator has decided to adopt. And for what it's worth, the statutory instrument has already been passed, maintaining the provisions of the Habitats Directive after exit date. So Brexit will not affect the outcome of this litigation. The only change that will occur is that references to the Commission have been changed to a reference to the Secretary of State. Now, the importance of the concept of alternatives to the Habitats Directive gives rise, I'm afraid, to an obvious risk, and it's the risk that the decision maker will take a narrow approach to identifying alternatives, sometimes to the point of saying that there are in fact no alternatives at all. Now, that's what happened in this case. The Secretary of State decided that there were no alternative solutions to the northwest runway proposal at Heathrow. And for my purposes, that was for two separate reasons. First of all, that the additional runway was the only way of achieving the so-called hub objective, and that expansion of Gatwick was not an alternative solution, which met that objective. And secondly, and in any event, Gatwick, the second runway at Gatwick, could be ruled out as an alternative solution because of the possibility that there would be orchids present in a 200-metre slice of the Mole Gap Special Area of Conservation next to the M25. And because of that possibility, and I think it's agreed by everyone it's no more than a possibility, because surveyors have looked for the orchids and haven't been able to find them, Gatwick could not be considered even as an alternative solution at the NPS stage. So that's the Secretary of State's position. Now, at the same time as the Secretary of State is saying this, that Gatwick is not an alternative for Habitats Directive purposes, the Secretary of State also says that for the purposes of strategic environmental assessment and the directive, Gatwick was and is not just an alternative, but adopting the language of that directive, a reasonable alternative. It is a curious situation in our submission. In the same decision, at the same time, Gatwick is both definitely a reasonable alternative for the purposes of the SEA directive, and yet not an alternative solution for the purposes of the substantive protection in the Habitats Directive. The Mayor's case is that that is not a convincing approach to the EU law concept of an alternative, nor is it indeed a rational approach, if that is the proper test. What the Divisional Court said about this is it tried to square the circle by saying it was actually all right, because you can be, I think, relatively generous for the purposes of with the aim of identifying alternatives under the SEA directive, because the SEA directive, as the court pointed out, was only a procedural right, and the identification of alternatives is intended to assist in identifying options for consultation. But the Divisional Court was stricter for the purpose of a similar assessment under the Habitats Directive, because it gave rise to substantive rights. Well, my outline response to that is, first of all, it doesn't work on the facts. Gatwick was maintained by the Secretary of State as a reasonable alternative, even in the final appraisal of sustainability. So not just during the consultation process that led up to the decision, so that everyone could compare different options side by side, but after the consultation ended in the final appraisal of sustainability, Gatwick is still accepted to be a reasonable alternative. And it goes further than that, because the Secretary of State still accepts that Gatwick was a reasonable alternative in the post-adoption statement. So after the adoption of the National Policy Statement, Gatwick was again confirmed to have that status. Now, Mr. Morici rightly reminded the court during the course of his submissions this morning that the SEA directive is an iterative process and it continued for a lengthy period, and that's quite right. But my response in the context of this argument is is that Gatwick was never ruled out under the SEA directive at any stage before, during or after the decision-making process. So that's the factual response to the Divisional Court's conclusion. But more importantly, I say it's flawed on the law. There is a great deal of law on what a reasonable alternative is for the purposes of strategic environmental assessment. In particular, you do not consult on an alternative that is not viable and doesn't meet the objectives of the strategic scheme. And the case law is relatively strict. And there is no support in any of the case law for the notion that the existence of alternatives should be accepted readily under the SEA directive, but not under the Habitat directive. In addition, the Divisional Court's analysis seems to proceed on the unspoken, but in my submission, incorrect assumption that the substantive rights in the Habitats Directive are less important and should more easily be displaced than the procedural rights in the SEA Directive. And my submission is that that turns a scheme of strict protection for those sites of European importance on its head. The true position is that the substantive rights in the Habitats Directive, which require the development of less harmful alternatives, are at least, if not more, important. And the different purposes of the directives, if anything, tell in my client's favour, not against. Therefore, my submission on the hub argument is ultimately that it is a curious and novel position where the public is asked simultaneously to accept that Gatwick is both a reasonable alternative for the purposes of strategic environmental assessment, but not an alternative for the purposes of the Habitats Directive. The difficulty which the Mayor said exists is that the Secretary of State is effectively trying to ride two horses in different directions. Now, that's being done for all sorts of understandable policy reasons, but nonetheless it's not an acceptable approach in law. The true position and proper analysis, the Mayor says, is that Gatwick was not the preferred planning option of the Secretary of State. On the government's view of the planning merits, Heathrow, a third runway at Heathrow, was a better planning option than Gatwick. But nonetheless, a second runway at Gatwick was an alternative solution to building a third runway at Heathrow. The second ground on which the Secretary of State excluded Gatwick at the national policy statement stage was the mole gap argument, that because of the potential presence of orchids on a site, we must exclude Gatwick from consideration now. Now, some reasons were put forward in the habitats assessment that accompanied the NPS for this exclusion. Those reasons were conceded in the course of argument in the Divisional Court as bad arguments, but the new reasons that are put forward are, in my submission, no better. They didn't impress the Divisional Court, and I'll suggest in due course that they shouldn't impress this court either. That was the introduction of where I'm heading. Can I turn then, if I may, to the Habitats Directive?
Yes.
The directive is in volume 1 of the authorities at tab 6. Because it's a slightly older directive, the recitals are mercifully short. Actually, don't tell us anything beyond the text. We're going to focus on the key provisions, just so the court knows where they are. The key definitions are in Article 1H, which deals with priority species, and which is relevant to the mole gap argument. It's those species indicated by an asterisk in Annex 2. I won't take you through Annex 2, but the orchids are there. And then Article 1L defines the special area of conservation. Those are those sites of community importance designated by member states. Then the scheme of protection starts at Article 3. Article 3 provides for the establishment of the network of special areas of conservation. under the name Natura 2000. And then Article 6 provides for the substantive protection and also a procedure for assessing potential effects of development. You don't need to look at 6.1 and 6.2 for the purposes of this case, but 6.3 opens with a reference to plans or projects. It's common ground that the airport's national policy statement falls within that. And that covers proposed plans or projects not directly connected with the management of the site, but likely to have significant effect thereon, must be subject to appropriate assessment. So there needs to be an appropriate assessment of the effect on special areas of conservation on the third runway at Heathrow.
Yeah.
Then 6.4, that's common ground, I should add. 6.4, a member state may only agree to a plan or a project having ascertained it will not adversely affect the integrity of the site.
Yeah.
Oh, sorry, that's under the rest of 6.3. If you can't do that, then you get into 6.4, which tells us what happens if you can't meet the standard in 6.3. In the absence of alternative solutions, and that's where we get that wording, and the plan must be carried out for the roadie, then you take compensatory measures and you inform the Commission of the measures that you take. So 6.4 only permits the plan or the project to go ahead in the absence of alternative solutions. If there aren't any alternative solutions, then you need to have imperative reason for overriding public interest. And where there's a priority habitat type, that's the second clause of 6.4, the type of aerope which are acceptable is considerably narrowed to human health, public safety, beneficial consequences of primary importance to the environment, or further to an opinion from the Commission, other imperative reason of overriding public interest.
Yeah.
There's plenty of case law that requirement for an opinion from the Commission is procedural only. It's not substantive. The Commission doesn't have to give a positive opinion about the development. The state is entitled to go ahead once it's received that opinion. Of course, if the Commission doesn't like what's done, it will bring infraction proceedings against the member state. So that's the scheme. Just to compare that before we leave the Habitats Directive, there is one other reference to alternatives in the directive, and that's Article 16. Article 16.1 deals with derogations permitting particular protected animals to be moved or taken or disturbed. And the wording that's used in 16.1 is satisfactory alternative rather than alternative solution. My Lord Justice Lindblom, in a case called Prideaux,
Yes.
considered that and accepted the submissions that were made by Council, that provision gave greater leeway to derogate than Article 16 because of the presence of the word satisfactory.
I think Mr. Marici was in that case.
Which is what, amongst others. I'm not going to take you to it, but just for your Lordship's reference, it's Volume 2 of the Authority, tab 30, paragraph 111.
Paragraph 111.
It's not a case on Article 6.4, but it was raised in the course of the
It's a first instance decision. I don't think it's been doubted since.
Don't think so, no. The regulations which implement the directive are at tab 3. Regulations 63 and 64 are its common ground between the parties for faithful implementation of Article 6. So I'll just give the court a few references if I may. 63.1 is the appropriate assessment, Article 6.3. There's provision for consultation under 63.3 of the appropriate conservation body, which is Natural England here. And then 5 is the requirement that you may only proceed if it will not adversely affect the integrity of the site. Then Regulation 6.4 reflects Article 6.4, Regulation 64.
Yeah.
Article 6.4. And 64 sub-regulation 2 B sets out the requirement to have due regard to any opinion of the European Commission. So that reflects the case law that the opinion of the Commission is not binding. It's something which the Member State has regard to, but it isn't a substantive limitation on the ability to proceed. So that's the directive and the regulations. I'll deal first then, under the case law, with what is an alternative. In going to the cases, you've probably covered by indicated the propositions I'm seeking to make good from the case law, first of all. I think there are 6 of them, which I want to seek to identify.
Yeah.
The first proposition is that the appellant agrees that the basic test for the identification of alternatives stated by the divisional courts at paragraphs 341 and 342 of its judgments is in fact sound. And the divisional court made a number of points there. First of all, they said that something is still an alternative even if the preferred option better meets the policy objectives.
Let's just look at these
It was
passages.
helpful just to take the time.
I think it would, yes.
It's paragraphs 341 and 342.
Just pause for a second, Mr. Duffy, if you would.
If I could just invite the court to read those passages.
Excuse me. Fully. Could you ask me something? I'm sorry. 341, yes.
341 and 342.
Thank you. Yes.
And so the points I particularly draw attention to are at the page break in paragraph 341, and just one line up at the bottom of page 550, it would be clearly insufficient to exclude an option simply because, in the policymaker's view, another preferred option meets the policy objectives to a greater extent, is unbalanced and attractive, and the court distinguishes then the situation where an option doesn't meet the core policy objectives at all. So that's the distinction which the divisional court draws. And then at paragraph 342, and the conclusion, picking it up from the third line in, any reason which requires an assessment of balancing factors, including the extent to which an option meets policy objectives, will not normally result in an option being eliminated from consideration as an alternative solution under the Habitat Directive. And again, we respectfully agree with that.
I agree with that. Yes.
The second point which we make is that the concept of an alternative solution is an autonomous concept of EU law. I'll show you the authorities, but it's a derogation from a system of environmental protection which involves fundamental rights, and therefore strict scrutiny of any attempt to derogate is required, and the proper legal framework for the identification of alternatives is to be derived from EU proportionality analysis. Those are propositions that I'll seek to derive from 2 cases I'll show you, Commission in Italy and Commission in Portugal.
Yeah.
The third proposition is that alternatives must be considered objectively and broadly, and it may include alternatives delivered at a different location, with different scale, with different means, with different timing. And those are propositions I'll take from DEFRA's guidance on Article 6.4.
Yes.
Fourthly, a point I've already made, which is that alternatives will not be identical and will not have the same planning merit as the preferred proposal, and will not meet all of the planning objectives to the same extent. That does not lead to their exclusion. Fifthly, it's not proper to define the objective which you're pursuing so narrowly as to unreasonably eliminate potential alternatives. And indeed, the court will carefully review attempts to define the objective being pursued in such a way as to exclude legitimate alternatives. That's a proposition I'll take from the decision of Mr. Justice Hickenbottom, as he then was in the one of the Friends of the Earth cases.
Just articulate the submission again, I'm sorry.
That it's improper to define the objectives that are being pursued so narrowly as to unreasonably eliminate alternatives. And the court will be astute to see whether that's going on, to identify whether that's going on.
Yes, the court will be astute. On the same nature and intensity of review.
Yes, and I'll deal with the nature and intensity of review, but my primary submission is that it is a proportionality analysis. But if I'm wrong about that, then it's an enhanced form of Wandsworth, given the context.
Yes.
And I submit that the appeal to be successful under either test, just as the divisional courts that I failed under either test. Finally, something which is a reasonable alternative for the purposes of the Strategic Environmental Assessment Directive will also normally be an alternative solution for the purposes of the Habitat Directive. And that's the point which I've already introduced.
Is there any authority for that?
No. That is a novel point which hasn't arisen in any other case. Not least because I'm not aware of any case in which, for example, the Secretary of State has sought to say that something is a reasonable alternative and at the same time say that something is not a satisfactory alternative under the Habitat Directive.
Yes, they're not necessarily conceptually identical.
No, they're not necessarily conceptually identical. However, in the facts of this case, for the reasons that I've outlined already, there isn't any relevant difference. And the fact that the Secretary of State has accepted and continues to accept that Gatwick is a reasonable alternative gives rise to, in my submission, a strong conclusion to be reached that Gatwick is also an alternative solution for the purposes of Article 6.1. On the authorities, the starting point was the decision in the Commission in Italy.
Yes.
That decision is in volume 2 of the authorities, tab 25. If you're tidying, could I ask you to keep the divisional court judgment open?
Yes.
Go back to it in a moment.
I've done that.
It's at tab 25, and I only need to, the facts aren't important, but if I could ask the court to have a look at paragraph 82 of the judgment.
Yes.
Paragraph 82, the point is made that Article 6.4 of the Habitat Directive must, as a derogation from the criterion for authorisation in 6.3, be interpreted strictly. I mention that, and it's a point which is made in a number of the other cases, and that's the most convenient place to take it from, because the Divisional Court held that the application of Article 6.4 did not involve any derogation from fundamental freedoms or rights recognised in EU law. And the Divisional Court made that point at paragraph 347 of its judgment.
And correctly?
Incorrectly.
Incorrectly. Let's look at what they said. So you say that's incompatible with Commission and Italy?
Yes. It's also said in some of the subsequent cases, which I'll draw your Lordship's attention to that passage in the subsequent cases when we get there. But the basis of the analysis of EU law is the starting point is Article 191 of the TFEU, which contains the provision that the European Union will provide a high standard of environmental protection and contains the precautionary principle, familiar basic provision of EU law. It's repeated almost verbatim in Article 37 of the EU Charter of Fundamental Rights, which confirms the status in EU law of environmental protection as a fundamental right and repeats the precautionary principle in Article 191 and the need to achieve a high level of environmental protection.
Could we check, do we have Article 191 of the
We have
treaty?
Article 191, it's in tab 11 of the authorities,
Is it just worth revisiting? I know it's
volume 1 and tab
well
11.
trodden ground. Tab 11. Yeah.
So 1912, Union policy on the environment shall aim at a high level of protection, taking into account the diversity of situations and regions in the Union, based on the precautionary principle, preventive action should be taken, environmental damage should be rectified and improved and paid. Then similar wording is repeated in Article 37 of the EU Charter. We don't have that in the bundle, but we can get it added behind there. Might be convenient.
Yes, and the environment is widely defined under Article 191(1).
But the proper legal analysis under EU law relating to derogations from a system of environmental protection is that they receive strict scrutiny.
Yes, which is paragraph 82 of Italy.
Yes. And that's just a reflection of the fundamental principles of EU law, but it's not surprising.
Yeah.
And so I say the Divisional Court did go wrong in the passage which I just showed you, paragraph 347. The second authority that I wanted to show you is the Commission of Netherlands, which is volume 2 at tab 24.
Sorry, did you say 24?
Yes, 24.
Yes, is that the opinion of the Advocate General?
Yes, there's an opinion of the Advocate General. We haven't, the parties haven't given you the court because the court doesn't deal with any of these points.
I see.
But I'm just going to show you one passage where there's a preliminary comment by the Advocate General about how Articles 6.3 and 6.4 interrelate. And that's paragraph 16 of the judgment. Sorry, the opinion. I could just invite the court to read paragraph 16 and also paragraph 17.
So what do we get from these two paragraphs?
So 6.3 just introduces, and I hope supports the submissions I already made about how 6.3 and 6.4 interrelate. And then the final sentence in paragraph 17 in the second column, the Advocate General says that Article 6.4 doesn't apply to these alternative methods of carrying out plans or projects, but rather to alternative plans or projects. So the point which the Advocate General is emphasising is that an alternative can be an entirely different plan or project. It's not simply a method of execution of a preferred project.
Yes, well, it's implicit in that you submit, presumably, that Gatwick is, in principle, potentially an alternative plan, stroke project, notwithstanding that it's a different airport, rather than a different solution at Heathrow.
I say it's a wide concept, not simply about the execution of the preferred plan of project. I accept, of course, that that's a noble statement, and I accept it's only the Advocate General.
Well, you say only, I mean, it is Advocate General Cocotte.
Yes, and she has appeared in almost every Habitat Directive case, and it is, I think I've only found one occasion in which her opinion is not on the outcome, followed by the court in the Habitat case, and that was on the temporal scope of the Habitat Directive, so rather technical terms, as opposed to a substantive point.
Yes.
But she's certainly considered to be an authority in the area.
Well, yes, I mean, she's of immense experience in this field.
The next authority, and perhaps the most useful one, is Commission on Portugal, which is tab 26.
Yes.
This is a motorway case involving an SPA, a bird site, and that was the point the Divisional Court made, which is that the alternatives that were being considered there were routing alternatives rather than entirely different routes. It was different ways of getting from A to B rather than whether there should be a road from A to B or A to C.
No, that's Advocate General Cocotte's alternative category.
But that's what the facts of the case were. I'll start with the court's judgment, if I may, before going back to the Advocate General. Paragraph 20 of the court's judgment, which is on page 10206. The court repeats a well-established test under Article 6.3, and I note it because of its strictness. There has to be no reasonable scientific doubt as to the absence of effects of the European protected site. And then paragraph 26, the court moves on to Article 6.4 and summarises the effect of Article 6.4, and then at 27, 28 and 29 the court deals with the case on its facts. The problem which Portugal had is it didn't properly examine any alternatives, and the alternatives are identified at paragraph 28. Then Portugal's submissions are at paragraph 32. What Portugal said is that the alternatives were not real alternatives because they would cause their own social, environmental, economic and environmental harm, since they would affect the populations of various towns as well as the reservoir and nearby dam.
Yes.
And then paragraph 38, Portugal loses because it hadn't properly considered the alternative solutions, even if they were, in the final sentence of 38, as asserted by the Portuguese Republic, liable to present certain difficulties. So that emphasises that you have to consider options which you consider to be not the best options on their planning merit. And that's the point that Portugal was making forcefully, which they were unsuccessful in relation to. As usual, the Court of Justice's judgment is pretty laconic, but there is some helpful analysis in the Advocate General's opinion. If I could pick up the Advocate General's opinion in paragraph 40, the Advocate General put on together.
Yes.
At paragraph 40, the Advocate General makes clear that this is a case in which the parties don't disagree about whether building the motorway as a whole was necessary for imperative reasons, or about the measures necessary to safeguard coherence, in which he identifies that the dispute was about alternatives to change the route. Then paragraph 41, the Advocate General again emphasises that 6.4 is a derogation from the general principle in 6.3. It's for the person relying on the derogation to show that it's been complied with. And then towards the end of that paragraph 41, the Commission is not required to demonstrate an alternative route, but only to raise reasonable doubts as to whether Portugal has complied with the requirements of 6.4. Then in paragraph 42, the concept of alternatives is considered. 6.4 only permits authorisation in the absence of alternatives, and then explains the purpose of it, and then the final sentence, the absence of alternative solutions corresponds in that respect to a stage in the test of proportionality, according to which, when there's a choice between several appropriate measures, recourse must be had to the least onerous. And then there are some footnotes, or the footnote 29 cites the Court of Justice's well-established case law on the proportionality test.
Yes, it does.
Various well-known proportionality cases involving less onerous alternatives. So, what the Advocate General is saying is that this concept of alternatives is first of all a concept of EU law, and that it draws from and relates from, and this is unsurprising from an Advocate General who has German legal training and is well familiar with the principle of proportionality, draws from that part of the principle of proportionality under which alternative solutions are considered and assessed, which is, of course, well established. Then paragraph 43 gives some further guidance about deciding whether or not...
Can you just hold a second while you... Thank you.
Paragraph 43 gives a little more guidance. Absence of alternatives cannot be ascertained when only a few have been examined, but only after they've all been ruled out. The requirements applicable to the exclusion of alternatives increase the more suitable those alternatives are for achieving the aims of the project without giving rise, beyond reasonable doubt, to manifest and disproportionate adverse effects. Again, it sounds very much like that relevant stage in the familiar proportionality analysis. Paragraph 46 gives a little more guidance. The decisive factor is therefore whether the imperative reasons of overriding public interest require the implementation of specifically that alternative, or whether, and by that alternative I think she means the preferred scheme, or whether they can be satisfied by another alternative with less of an adverse effect on the SPA, the protected bird site. And then that presupposes they've been examined on the basis of comparable scientific criteria with regard to their effects and with regard to the relevant reasons of public interest. That's the best explanation we get from the Court of Justice about how the test relating to alternatives is meant to operate under Article 60. And I submit it is a valuable insight into what the concept is meant to mean and how it is meant to operate in practice. And for some additional guidance on how the case law on alternatives within a proportionality test works, we also have the advantage there's a lot of domestic learning on that question. Below, we cited the judgment of Lord Reed in London, which is a classic statement of how questions of alternative solutions should be analysed. I'm not going to take you through the judgment because it's very familiar, but the references are paragraphs 60 to 67, and some of the factors that will be considered by a court when applying that test are whether or not it is a case where the precautionary principle is engaged, whether fundamental rights are engaged, and of course familiar factors about the extent to which there is a policy judgment and the court will give marginal discretion.
So what's the reference to that authority?
So paragraph 60 to 67.
Tab 33.
Tab 30, I'm very grateful to Neville.
In 18.
It's Authorities Volume 3. Volume 2 at
Yeah.
tab 33.
Yeah, thank you very much.
And it's paragraph 60 to 67.
60 to 67. It's also quoted by the Divisional Court, or mentioned by the Divisional Court in its judgment.
Yes, just pause for a second. Commission and Italy features largely. You say this represents the true distillation of the law.
Yes.
you say that the divisional court got this wrong in 34728. They refer to Lumsden but got it wrong.
They refer to Lumsden and they say Lumsden doesn't assist us because this is not a case which engages a derogation of fundamental rights, and for the reasons I talked about, that was a wrong approach to the analysis of the issue. This is squarely in application of principles of EU law in the context of a derogation. And so this is the proper line of authority to analyse. And that's what led, in my submission, the Divisional Court into what I submitted the error they made on the hub status analysis. Ultimately, as I said, I don't have much quarrel with what they said at 341 and 342 about how they analysed what an alternative is, but the approach they took to applying the tests was incorrect. I also said I would show you the DEFRA guidance on alternatives. It's obviously not binding, but it is a useful form of guidance. It's not in the authorities bundle, but it's in volume 8 of the appeal bundle. At page 1097.
Sorry, which volume?
Volume 8, my lord, page 1097.
Yes.
It's obviously, as I said, not legally binding in any sense, it's just the opinion of the Majesty's Government, but it is useful to compare it with what we've done here. There is an introduction in paragraphs 1 to 9 that summarises the principles under 6.3 and 6.4, and then at page 1101 there's a heading, Test 1 Alternative Solutions. In paragraph 10, the purpose of the alternative solutions test is to determine whether there are any other feasible ways to deliver the overall objective of the plan or project which will be less damaging to the integrity of the European site competitor. A competent authority must be able to demonstrate objectively the absence of feasible alternative solutions. In paragraph 11, the first step is to identify the objective of the plan or project to help frame the consideration of alternatives. Alternative solutions are limited to those which would deliver the overall objective as the original proposal. In paragraph 12, it's explained that many projects may have a public interest element like roads, flood defences, power stations, ports which serve the public need, and potential alternative solutions would be assessed against whether they would deliver a similar objective. So in paragraphs 10, 11 and 12, the wording you get is overall objective or similar objective, recognising that you're not necessarily going to achieve precisely the same outcome, the same level. There are then some thoughts on the limits of the concept of an alternative in paragraph 13, and some examples are given. So, for example, wouldn't normally consider replacing one form of capacity with another. So we have a proposal for wind power, you wouldn't necessarily consider a new nuclear plant. Or for road development, you wouldn't necessarily consider a high-speed rail link as an alternative.
Well, you might.
You might, but you wouldn't necessarily. You can see why that's more difficult.
Yes.
I certainly don't need to go that far.
No, you don't. No.
But that's DEFRA's view about what the limits of an alternative might be.
Yeah.
Then paragraph 16, there's a summary. Alternatives must be considered objectively and broadly, that must be right, could include options delivered by someone other than the applicant, different location, route, size, scale, methods, means, timing, and different ways of operating development or facility. Then there are some examples given in boxes, just looking at the first one, because it's closest to the facts of this case. Dibden Bay, proposal for more deep water berths at Southampton. The request for derogation was rejected because there had been no proper assessment of alternative facilities in other ports in the south of England. And that's a reasonable analogy for this case. There's a credible proposal that you need more shipping capacity for containers in the south of England. We had to consider other locations, deep water ports where similar capacity could be provided. And no doubt maybe it could be said that Southampton had advantages because it's a very large existing port. You have the benefits of being able to move cargo from one ship to another, higher costs elsewhere, less effective, smaller in scale and so on. But those are the types of alternatives that we all need to be considered. Then finally at paragraph 18, DEFRA point out in the second sentence, an alternative should not be ruled out simply because it would cause greater inconvenience or cost. But there does come a point when something is so expensive or technically or legally difficult, it would be unreasonable to consider it an alternative. That must be right again. And that is, I submit, useful guidance as to how the test ought to be applied in practical terms under Article 6.4. So that's the law in relation to the Habitat Directive. Now, the Divisional Court said, as the Court knows, that it was understandable for Gatwick to be a reasonable alternative for the purposes of the SEA Directive, but at the same time not be an alternative solution for the purposes of Article 6.4 of the Habitat Directive. So, if I will, if I may, just show you briefly the SEA Directive and the slightly different wording we get there. That's it, Authorities, Volume 1, Tab 7.
So we can put away the DEFRA guidance.
Yes, my lords can put away Volume 8.
And we want now?
Volume 1 of the Authorities is Tab 7, the SEA Directive. The relevant provision is Article 5.1. The fourth line in, what has to be identified are reasonable alternatives taking into account the objectives and the geographical scope of the plan or programme. So we're told immediately by the words that when identifying reasonable alternatives, you can consider the objective, which you're seeking to achieve, and the geographical scope of the proposal. Unlike the Habitat Directive, as the Court well knows, this is a procedural requirement. And so however good the reasonable alternative that's been identified, and however damaging the environmental consequences of the preferred option, the SEA Directive does not do anything to control the ultimate choice between alternative options. Now, looking at these two sets of wording side by side, as European drafting, there does quickly come a limit as to what you can get from textual analysis.
Yeah.
But if something is a reasonable alternative, taking into account the objectives of the plan and its geographical scope, it is in my submission relatively unlikely it will not at the same time also be an alternative solution for the purposes of the Habitat Directive. I'll come back in a little more detail to why the Divisional Court said that submission was wrong, and back to this case in a moment. Mr. Fleming will be showing you more authority in relation to this directive, but can I just ask your Lordships to look at one authority under the SEA Directive, which is the decision of Mr. Justice Hickinbottom in Friends of the Earth, which is in volume 3 of the authority, tab 15.
Do we need to keep the directive
No, you don't.
out? No. Volume,
Volume 3, tab 86.
yes.
I'll show you this judgment, even though it's only a first instance decision, because Justice Higginbottom really only needs to save time, because he seeks to summarise what the current state of authority is in relation to the SEA directive. Not all of it is common ground, Mr. Fleming will develop, but I just want to show one or two aspects. On page 27, paragraph 88, Roman 5, there's an explanation of the concept of reasonable alternatives under Article 5.1, and the judge says an option which does not achieve the objectives, even if it can possibly be called an alternative, is not a reasonable alternative. An option which will or sensibly may achieve the objectives is a reasonable alternative, and there might be none. The intensity of review under that directive is dealt with at Roman 6, and it's said to be conventional public law grounds. That's the point which Mr. Fleming will deal with. And then over the page at Roman 11, 3 or 4 lines in, Mr. Justice Higginbottom says the evaluation is peculiarly evaluative, but an option will meet the objectives if, although it may not be in the authority's judgment, the option that best meets the objectives overall, i.e. the preferred option, is an option which is capable of sufficiently meeting the objectives such that the option could viably be adopted and implemented. And then he says that's conventional public law grounds, that's Roman 3. And then at the end of Roman 10, the last sentence, however, whilst allowing the authority a due margin of discretion, the court will scrutinise the authority's choice of alternatives to ensure it's not seeking to avoid its obligation to evaluate reasonable alternatives by improperly restricting the range of options I think it should be if it is identified as such. So that's under the SEA directive. But I say that point must be a fortiori in the habitat context, because whether there is an alternative doesn't just guide the procedural steps that have to be taken, it may well affect substantively whether the development can proceed or not. So that's the relative state of the law under the SEA directive for my purposes. The final legal topic I wanted to address is the standard of review before turning to the decision in this case. I've already shown the court Commission and Portugal, the Active General report, which refers to elements of the proportionality test. The leading domestic case on the standard of review under the Habitats Directive is the decision of the Court of Appeal in Smythe, and that's in Volume 2 at tab 31. Two issues. The primary issue itself is an issue which doesn't arise on dispute. It's under Article 6.3, and it's about whether mitigating measures should be taken into account when deciding if development will have a significant effect on a protected site. And Mrs. Smythe said you couldn't consider mitigating measures when deciding if the Article 6.3 threshold had been crossed, and the Court of Appeal said you could. And what that meant is that 6.3 was not crossed, and so therefore we didn't need to worry about 6.3. So that was the primary reasoning in the decision. That conclusion is made by Lord Justice Sale, reached by Lord Justice Sale in paragraph 74.
Yeah, should we just look at that?
He applies some early authority decisions which Justice Sullivan has taken part.
Yes, well let's just pick that up.
directly relevant to this case. The reason I'm showing you this section of the judgment and this part of the reasoning is, I suppose, just as a cautionary tale, because at paragraph 71, Lord Justice Sales analysed the contrary opinion of Advocate General Cocotte, which went in the other direction, and concluded that the Advocate General's comments to the opposite conclusion were overturned, they hadn't been adopted by the court, they all turned on the exact wording of the question posed by the National Court and so on. And shortly after this decision, perhaps inevitably, the Court of Justice considered the case on precisely this point and agreed with the Advocate General's analysis.
Which case was that?
That's People Over Wind,
Oh yes, People Over Wind.
which is in tab 36.
I have a feeling that this court considered People Over Wind and Smith recently.
Yes, I think it applies People Over Wind.
Yeah. I remember the court, but I can't now remember what we decided. But we considered it in the Badger Trust case.
Well, it was considered in the budget case, but I think the Court of Appeal decided it wasn't necessary to express it.
That's probably why I can't remember what we did
Yes,
about it.
so what it was. I don't think that's going to take. That's why I think your lordship can't remember the precise details, because actually the court decided that there wasn't any necessity
Yes.
to deal with that.
Thank you.
So what is the law in this jurisdiction?
There have certainly been two first instance decisions which have applied People Over Wind and said that Smythe is no longer a binding authority on the High Court, including a decision of Mrs. Justice Lang in the bundle at tab 37, a case called Greenfield.
But just pause for a second. That's July 2019. Is there an appeal in that case?
I'm afraid I don't know this.
I'm sorry. Forgive me, Mr. Jaffe.
That's quite right.
Forgive me for repeating the question. It's not because you haven't answered it, but because I want to be absolutely clear what the answer is. The law in this jurisdiction now is founded on the principle in People Over Wind. How do you reconcile that with the fact that Smythe is a decision of this court?
Because the decision of the Court of Justice is
Yeah.
a superior authority, and at least for now, is binding over a decision of this court.
If it is a decision.
If it is indeed a decision with the same ratio.
That's section 3.
Yeah, but then is it?
The court doesn't need to decide that in this case. The only reason I'm referring to it is essentially as a cautionary point, which is that in relation, where there are clear dicta from the Court of Justice, including in an Advocate General's opinion, which are reasoned, setting out what the proper approach and test is to Article 6.3 and 6.4, the court ought to be cautious before departing from it. And that's why I've suggested, and we've suggested in our skeleton, that given the absence of authority about the proper application and interpretation of the test under Articles 6.3 and 6.4 about the concept of alternatives, ultimately this case might have to be referred to the Court of Justice. Now, Lord Justice Sales said in Smythe that the point, paragraph 74, was act clear in relation to 6.3. And the fact that in People versus Wind there was an opposite decision of the Court of Justice means that it is important to be quite cautious about reaching those conclusions.
Have we got People Over Wind?
We do have People Over Wind. People Over Wind is at 36 of Westminster.
Thank you, yes. It wasn't actually People versus Wind.
So People Over Wind.
People Over
People like
Wind
the wind because they didn't want to
versus a body whose name you will pronounce for us.
I'm afraid not. On page 1670 of tab 36, the court will see that the court heard Advocate General Cocotte but decided to proceed to judgment without an opinion.
Right, so can we just find the salient passages in the Advocate General's opinion?
Those in People Over Wind, they didn't have one. That's
Oh, there was
page,
not one.
Page 1670.
To proceed without an opinion,
Without
forgive me.
opinion.
There was no such
There was
opinion.
no opinion.
So they proceeded without an opinion, yes. And the ratio,
taking it from the dispositif on the final page, page 1677, Article 6.3 must be interpreted as meaning that in order to determine whether it's necessary to carry out, missing out some words, an appropriate assessment, it's not appropriate at the screening stage to take account of the measures intended to avoid or reduce the harmful effects of the plan or project on that site of investigation.
Yeah. Yes. That is a sea change in this jurisdiction.
It is, yes. As I said, the only reason I'm relying on it is not because it's relevant to the circumstances of this case, but just because the Divisional Court very readily rejected the submissions which I completed to this court about what Advocate General Cocotte was saying in commission in Portugal and the other case that I've shown you, and said that a different approach was appropriate. And I would invite the court rather to accept those as being a correct and compelling analysis of the division, and certainly not to say that they are wrong or certainly clearly wrong. And even if the court is minded to reject those submissions, I will say that they're certainly strong, Advocate General's conclusions, they're certainly strongly arguable as to be the correct and proper approach. And so that gives rise to the question of when, if at all, a reference might have to be made as this case, which is the point we raised in our first line. We don't do it with any particular enthusiasm for all sorts of obvious reasons. And if it were to occur, it would certainly have to be under the highly expedited procedure in order to get a result very quickly. And the Court of Justice will do it within a few months, if necessary. But if the Court is ultimately left in doubt about what the concept of alternative means and how it's to be applied, then ultimately we say that with regret that may have to be done in order to get an authoritative answer. Then, of course, there's a question of what stage in the proceedings that ought to be done. We took the view below that it certainly should be done in the first instance, and the issues ought to be clarified by at least a first instance judgment. The question then arises of whether it's this court or whether it ought to be, for example, the Supreme Court on an application for permission to appeal, which would be the point at which the Act Clare test is applied. But on any view, the law relating to sixth form alternatives is not Act Clare.
Will this be affected by exit day?
Depends on what kind of exit there is.
Well, quite, but under the EU Withdrawal Act.
Under the draft agreement, which was published yesterday, there will be a transitional period if it's approved. Any references which are ex ante, as of exit date, will be determined, as will any references which are made during the transitional period. So existing references do not fall and new references can be made and they will be answered by the Court of Justice. If there is a no-deal exit, then as a matter of EU law, this hasn't been finally determined, but this is the general view, any ex-ante references will fall and no new references to fall will be made.
It may be that you'll want to revisit this submission on Monday. You will have.
We could meet again on
You will
Saturday
have the
afternoon.
court's permission. That is not going to happen. You will have our permission to do so. Yes. So where are we now?
The final point in relation to Lord Justice Sale's decision in Smythe.
Yes. I'm sorry, I put Smythe away now.
Tab 31 of volume 2.
Thank you.
Is where he dealt with the standard of review under Article 6.3.
Yes.
Which is more useful for this case. The standard of review is dealt with from paragraph 78 onwards. And the conclusion, which the Court of Appeal reaches at paragraph 79 and 80, is that the standard is going to be, by analogy with environmental impact.
Yes. Now, how is that affected, if at all, by any subsequent European authority?
Well, first of all, it doesn't deal with Article 6.4. It only deals with 6.3. So it isn't ratio and it's not binding. In
There's,
this
there's
part,
at least one other decision in this court to the same effect,
not under Article 6.4,
not under Article 6,
under Article 6.3, there is.
which is
Uh, Minute and Gwent at
Minute.
35,
Yeah.
which cites and applies SNIDE.
yes.
Now, neither of these decisions deal with Article 6.4, and neither of them deal with Advocate General Cocott's analysis in Commission in Portugal, which refers to the elements of the proportionality test as being the proper approach. There has also been one further decision of the Court of Justice since both these decisions, and that's the decision of the Court of Justice in a case called Cranest, which is a significant decision which I would like to show to the Court as the last authority on this topic. Cranest is in the authority bundle. I've lost my record. It's in volume 1 of the authority bundle, that's tab 22. It's an air quality case. The reason why it's of interest is because both the Court and the Advocate General address the appropriate standard of domestic judicial review
Yeah.
in an EU environmental context.
In any.
In any EU environmental context.
Yes, yes. This is Cranest.
With Advocate General Cocott again.
Yes.
The background for this case is that the Air Quality Directive requires member states to monitor air quality and to meet certain limits for various airborne pollutants. And so, for example, there are continuing breaches in London that have led to various policy measures in recent years, such as the introduction of charging schemes and so on. This was a challenge brought to the siting of the sampling points in the city of Brussels. What the City of Brussels said is that where they put their sampling points to measure air quality was a matter of evaluative, expert and scientific judgment.
Yes.
Ultimately, it wasn't for the court to get involved.
Yes.
And one of the things the Court of Justice had to consider is what the proper approach was to that type of argument. Just taking the Court's judgment first, which is behind the back, behind the Advocate General. Paragraph 14 of the Court's judgment sets out the law in the directive on the citing of sampling points. I'm not going to go through it all, but immediately the Court can see there is a lot of discretion and evaluative opinions involved in the proper citing of sampling points for air pollution.
Yes.
Then at paragraph 30, the Court sets out the question that's being asked to consider. From the third line, is it for the National Court hearing an application by individuals directly affected by an exceedance of the limit values for air pollution and various pollutants to verify whether the sampling points located in a particular zone have been established in accordance with the criteria which I've just shown the Court. And if they were not, take all necessary measures with a view to ensuring the sampling points are located in accordance with those criteria. Paragraph 33, the Court cites the Advocate General's opinion, and the Court's starting point is Article 191 of the TFEU, which the Court saw earlier in my submissions. And then at paragraph 34, the Court emphasises that exercises of discretion need to be kept within the boundaries set by the directive. That's my summary. Then at confirms that member states do have discretion to choose within the limits of their discretionary powers the actual location of the sampling points. Paragraph 45, that doesn't mean you're exempt from judicial review, in particular verification of whether the limits have been exceeded. And then, as to the standard of review, or rigour, as the Court of Justice call it at 46, what's important is to take into account the purpose of the Act to ensure its effectiveness is not undermined. Then at 47 to 50,
Yeah.
the Court of Justice set out a series of reasons why, in the circumstances of that case, a high degree of scrutiny is going to be involved. I don't need to go through them, but there are environmental and practical grounds which are all significant in the air quality context.
So translating that, if you like, into domestic jurisprudential language,
At the very least, strict scrutiny for Wednesbury purposes.
intensified Wednesbury,
Yes, at the very least.
at the very least. Yes.
Then 52, the court emphasises that point. Whilst the choice of the location of sampling points requires technical and complex assessment, the discretion of the competent authorities is limited by the purpose and objectives pursued by the relevant rules in that respect. And then 53, the second line, there is a margin of discretion, but the court has to have jurisdiction to take all necessary measures in respect of the national authority concerned, such as an order to ensure that such points are cited in accordance with the criteria. Then at 54 and 55, the court summarises its jurisprudence on the principle of effectiveness, which is in fairly standard terms. And then the court sets out what powers the national court must have in 55, verifying the location of sampling points, power to issue orders and so on.
Yes.
So that's the court's judgment. The Advocate General gives more detail. Picking up her opinion at paragraph 19. The last sentence of paragraph 19, after saying at the beginning of 19 that the National Court does have jurisdiction and competence to impose orders, what has to be ascertained is what standard of review must be applied by the National Court in respect to the finding of sampling points. Paragraph 20, the Advocate General recognises it involves discretion, complex assessment of scientific matters, weighing up exercise and so on. And then at paragraph 22, the Advocate General points out this is ultimately a matter of EU law, and that there is a minimum level of judicial review which EU law would require. Then 36 and 37, I'm skipping the facts as much as I can.
Yes.
There's considerable scope in 36 for differences of opinion on these issues. And 37 refers to the national principles of Belgian law. The principle of division of powers to restrict its power to review administrative action in connection with the citing of sampling points, which sounds fairly familiar to most public lawyers in any jurisdiction. And paragraph 40, the Advocate General says that what she's looking for is to identify the necessary minimum level of power for judicial review. And then in the last sentence, what standard of judicial review is necessary to ensure the principle of effectiveness is met.
Yeah.
And then under the heading, the review of scientifically complicated assessment or complex assessments, 43, there is generally a broad discretion, full discretion is her words, which can be reviewed only to some degree, but that discretion is limited in certain cases and must be reviewed more intensively, in particular where there are particularly serious interferences with fundamental rights. then repeats the point about broad discretion for scientific assessments in 44, and then sets out the traditional test in such cases of EU law in the second line of 45, manifest exceedance of the limits of discretion. And that's what my learned friend Mr. Marici in his skeleton argument calls the EU equivalent of Wednesbury.
Yes. Does the court pardon that or not?
Well, what the court says is that there has to be an enhanced level of review given the circumstances. And,
How does that square with paragraph 45 of the Advocate General's opinion?
well, the Advocate General is simply talking about what the ordinary situation is, and then she goes on in the following passages to explain why this case is different.
Where does she come to a conclusion on the standard of review?
She comes to a conclusion on the standard review of paragraph 56.
Yes. Well, it looks like a dual standard of
The
review.
dual standard, first of all, ordinarily manifest errors, but more intensive review in circumstances where the achievement of the protective aims of the directive are being called into question. And she explains in the preceding paragraphs what the right circumstances are for applying a different test. In particular, paragraph 47, she explains what needs to be done. So 47, where interference with the fundamental rights of the issue, the extent of the discretion may prove to be limited in light of the principle of proportionality, and then sets out various factors. 51 then applies those principles to the case at hand. 52, in principle it's broad, and then but in 53, which is the application to the facts of that case, note the importance of the rules on ambient air quality. Directive 2008-50 is based on the assumption that exceedance of the limit value leads to premature death. The rules put into concrete terms rights in the Charter, in particular the right to life and a high level of environmental protection required by Article 33 of Article 37 and Article 91. Therefore, it's a serious interference with fundamental rights, and it's subject to strict review.
Sorry, where are you reading from now?
53.
53.
And in all these passages, and actually in the footnotes, all the footnotes refer to the court's jurisprudence in data protection cases, and cases which, in particular, my Lord Justice Singh will be familiar with, cases like Digital Rights Ireland, Tele2 and Watson, where derogations from a system of strict protection, where they engage the Charter, are subject to a much higher degree of analysis, review and scrutiny.
Mr. Jeffrey, may I ask you, did the divisional court deal with the Charter in this case?
No, they didn't refer to the Charter.
And
They were referred to the Advocate General in Cranes, but not to the court, because the court hadn't come out.
I see. But so far as the Charter provisions are concerned, you referred earlier to Article 37. I think, speaking for myself, I think it is going to be potentially important for us to consider that.
We've got it in here.
There is a copy of the relevant provisions of the Charter in Core Bundle 2, at page 707. I'm sorry it isn't in the Authorities Bundle.
So, Core Bundle 2.
Core Bundle 2, page 707,
Thank you.
and it quotes Article 37 of the Charter in full.
Thank you.
Very good.
Another point, can I just flag another point? It probably won't go anywhere, and of course none of us knows what's going to happen in the next couple of weeks, but assume for the moment that the country does exit on the 31st of October. My recollection is that under the Withdrawal Act, the Charter is not part of retained EU law. That may or may not have any bearing on this case, but just wanted to flag that thought in case it becomes a relevant one.
There is, I understand, going to be, assuming that the proposed deal is approved on Saturday, there will then be a new EU Withdrawal Act that is actually published, and that may deal with the status of the
I see.
Charter.
But the status of the Charter then remains at large pending that resolution of the United Kingdom's exit from the European Union. just pausing.
Shall I just finish this point and then
Yes.
that'll be a convenient moment?
Yes, by all means. I was trying to trace the charter. It's in, you said it was in the core bundle.
Volume 2, page 707.
You might want to read the last two words of Article 37.
So a high-level environmental protection and the improvement of the quality of the environment must be integrated with the policies of the Union and ensured in accordance with the principle of sustainable development, which, as my Lord Justice Haddon-Cave pointed out, provides a link to some of the other submissions which the Court has heard in the last 2 days. And at the time this decision was taken, there may be interesting questions about what happens in the future. Of course, the Charter remains part of EU law and one of the treaties has the status of a treaty.
Sorry, did you emphasise the date of the decision?
Yes.
Yeah.
The date of the decision.
Well, that's why it may not, at the end of the day, matter, but obviously we'll hear any submissions that may be made about that.
So my submission on the standard of review is that certainly, at least in relation to Article 6.4, the proper test is that identified by the Advocate General in the Commission of Portugal. It's a question of EU law, and it requires an intensive standard of scrutiny and review by reference to the authorities which are identified, in particular Framework, but just as a matter of EU law logic, that there is a derogation from a strict system of environmental protection, and therefore strict scrutiny is required of derogation. I've been going for an hour and a half. That leaves me with submissions. First of all, applying that law to the hub status issue, and secondly, an old gap. And I'm pretty confident I can do that in an hour, which is the time I have.
Which is the time you have.
I'm sorry
Yes.
it's taken a bit of time to get through that, but that's the important legal framework you need for considering the legal court's judgment.
Thank you. Thank you very much. As I indicated earlier, we are going to sit at 10 o'clock on Tuesday. We don't sit on Monday. I say nothing about subsequent days for the moment. We are very keen to retrieve our position on the timetable if we can. And if it's not going to cause inconvenience, we may sit again at 10 on subsequent days. But not, as I emphasised earlier, so as to compress any advocate's submissions unduly. Thank you all very much. 10 o'clock on Tuesday next.
All rise.